Thank you very much, everyone, for participating in this panel, talking about a very important and challenging issue, the question of corporate governance and competition law. And we have here two amazing professors. Professor, our lecture, I always, because it's in Brazil, we usually use this word professor. Lecturer, Professor Danielle, that made her master's and her PhD at Columbia University, and she's a professor at Bar Ilan University in Israel, and Professor Florence Thepot, that was in the best team of competition law I ever knew, that was Glasgow, was there in the beginning of the year, and she now is teaching at Strasbourg University, if I'm correct, and we're gonna discuss both are going to discuss this issue. So we're going to start with Danielle, if I'm not wrong. So Danielle, the word is
Yeah, I
yours.
can go ahead. Sure. Florence, is that okay with you?
Do you want to change it? I made a mistake.
For me, it's the same. I think we said maybe that I would start, but I'm really happy.
Okay, so let's go Florence first. Sorry. I don't know.
Yeah.
Let's go Florence. Sorry. I made a mistake.
No worries. So can you see?
Yes.
Can you see my slides?
Yes.
Great. Can you hear me well? Great. So good morning to people in Brazil, and good afternoon or evening in people in different places, such as Danielle in Israel. So I'm delighted to be contributing to this conference, and I wish I would be, in person, but it's not too bad being with you online. And I'm going to give you some thoughts on the interaction between corporate governance and competition law. So corporate governance is concerned with relations within firm, especially the way in which shareholders, owners would ensure that managers run their company in the best interest of the owners. And competition law is concerned with relationships between firms or the behavior of firms on the market. And so supposedly these are two distinct fields of the law, of business law, but I will explain that there are great and many ways in which both interact. There is a meaningful interaction, and both fields have a lot to learn. So I'm going to check the time. So just very briefly on a theoretical background, it's kept very simple, but what's the theoretical foundations of corporate governance? Corporate governance, it started with maybe Burley and Means, who explained in 1932 that now ownership of firms and control is separated. So now you have increasingly modern corporations, which were evolving in the earlier 20th century. So you have now owners, founders, who do not run themselves the business. They delegate these tasks to managers who are best placed, maybe have better skills to run the business operations. So it's interesting to see that now we understand that people complement each other. Some people have the funds, but they may not have the skills and expertise to run a business. So there is some sort of delegation. But then Jensen and Nickling explained that through this delegation, there is some cost. There are some costs, because you need to make sure as owners that people who run the business for you do it well, and that you need to make sure that the interests within the firm are aligned. So there is a cost to this delegation, which is called agency cost. So you have principal, maybe the owners, and the agents, maybe the managers. And basically, corporate governance are a set of mechanisms by which the principals, so the owners, make sure that managers run the company in their best interests. So they do monitoring, they may use compensation schemes to align interests. So this is the very basic theory and the very, very basic framework. But just to clarify that corporate governance here then is really about the internal control. It is really about monitoring, actors within the firm. It is really about internal relations within firms. And the objective of these schemes may be about maximizing the value of the firm, or having the best interest for the shareholders, even though these view can be really challenged and has been enriched. But the very basic framework is that corporate governance is about the internal relationships within the firm. And if we have then competition law, it is about the behavior of those firms on the market. So competition law prohibits anti-competitive agreements and acquisitions. And it's also about unilateral conduct by dominant firms, but I'm not going to speak too much about it. But here's just to clarify that competition law wants to make sure that companies act independently from each other on the market. They want to make sure that there is no collusion, no anti-competitive agreements. And competition law is supposedly not too much focused on these internal workings. All these internal stuff is not within of concern for competition law. They just want to make sure that the company, the firm, acts fairly on the markets and behave competitively. So in sum, competition law is about inter-firm relationship. It's about the external dimension of firms. And of course, acquisitions, it's about a company acquiring another firm or part of it. But you will see that especially in the EU, it's of concern for competition law when maybe two of those firms cease to be distinct from an economic structure point of view. And competition law is typically concerned with what we call consumer welfare, which is very much an economic efficiency approach, ensuring that there are low prices, great quantity, qualities, and stuff. So basically, generally, competition law is concerned with the competitive process. So as you see, corporate law, corporate governance, competition law, really two distinct fields. They do not target the same things, and even the objectives are quite different. But of course, those boundaries may blur, so there may be intersection between those fields when we have the recent tendencies of investors. So as you may imagine, the structure of capitalism is very much complex in modern economies. And basically, you can have institutional investors, banks, family owners, and basically, they may complexify the corporate structures. So when it comes to our two companies, let's say they are competitors, you may have a set of investors who actually own some minority shareholdings in two competing firms. And we will see that this may be at the heart of ongoing issues we have in competition law. So here we have a set of investors who basically may not be majority shareholders, but they just diversify their portfolio throughout businesses. But maybe it can happen that you have minority shareholdings within one business, within one sector. And these are kind of financial ownership link, which may blur the boundaries between the firms, because now companies are connected via these kind of financial links. It's indirect link. And second type of link, you can have individuals who would sit on the board of directors of two competing companies. So I didn't really specify, but on the previous slide, here I did some little pictograms showing who are maybe the owners, the funders, and then, but typically the board of directors would be representing shareholders and try to make sure that the business is run very nicely in their best interests. So board of directors are very responsible for a lot of things within the company. And what is quite frequent actually is that you have one individual sitting on the board of two competing companies. This is called interlocking directorates. And as I will explain, it is prohibited in the US and in also some places in Latin America, but not in Europe. And here I argue that, and many others, that really that's where corporate governance, corporate finance, and competition law intersect, because we may have some issues together. So indeed, what are the hot topics in competition law? So some of them are the fact that we have three firms owning corporate America. So BlackRock, Vanguard, State Street are big institutional investors, and they may diversify their portfolio across within an industry. And there has been lots of debate and some empirical work saying that maybe those practices of acquisitions, even though they are just minor and maybe passive, it can actually reduce the intensity of competition in the product markets. So we are now quite clear that maybe there may be issues if the same set of investors own companies within the same sector. And also the second set of issues, which is really related, it is about the fact that we have interlocking directorates. So competing companies have common directors on their board. And the big news is that there is increased scrutiny of those links in the US. So the US has had a prohibition of those links, but until recently it was not really enforced or litigated. So not so much of a debate. But now there is this concern that actually we need to look at how companies are linked via their corporate boards. So now we start thinking that there may be issues. And there are two set of questions. Does it really matter? What are the anti-competitive effects of companies having those indirect financial or corporate links? What may be the actual impact on prices? And second question is, okay, now that we identify some potential issue, do we have the legal tools? Is competition law well equipped with the prohibition of anti-competitive agreements? Is merger control maybe well adapted to scrutinize those acquisitions? And I think it's very important then to look at what corporate governance and corporate boards, corporate law does. So yes, so that's where really corporate law and antitrust really intersect. And indeed, this is just, I think, the reflection of a bigger trend, is that over the past decade, I think there is an expansion of competitive concerns. So now competition becomes worried about sustainability, about inequalities, and of course also about those indirect financial links between competitors. So it's just part of the broader picture that now competition law wants to remedy maybe various sets of issues. And we may wonder whether there is an enforcement gap in our laws. I think that we do have some. Also, similar set of issues relate to private equity. So those investors which pools resources and invest in maybe businesses which are in financial difficulties and enhance the business and then sell it again once they've taken value out of it. And there may be some issues related to that, but quite recently, competition law across jurisdictions has really starting to be interested in that as well. So the big question is, do we need a change in paradigm? Do we need to adjust our tools and to think differently through these corporate structures? In the EU, as I will explain with the charts, we think a lot about matters as whether it is in or out the undertaking. So the undertaking is our conception of the firm, and the undertakings are engaged in economic activity and are the one who are the subject of competition rules. And it's really clear that for Article 101 of the treaty to apply, so meaning that to find an agreement which is illegal, we need to have two distinct undertakings. So you really need to identify that you have two distinct undertakings. So for example, when you have an interlocking directorate, one individual sitting on the board of two competing companies, it's not really an agreement between two undertakings. It's a bit more blurring the lines. And also in the EU, merger control is very much based on the concept of control and whether there is acquisition of decisive influence. So basically, when there is an acquisition of a financial ownership, an indirect link, maybe EU law is not well equipped. Interestingly, in the US, their provisions are just done differently. So those indirect links, financial or corporate, may be scrutinized because the provisions rest on different paradigms. And as I will also touch upon briefly, Latin America has also several provisions on interlocking directorates, so meaning that there is already a grasp of those issues in various countries. So basically, quite quickly, Article 101 it prohibits anti-competitive agreements. And basically, the condition for application of it is whether you have an agreement between two distinct undertakings. At the other end of the spectrum, we have merger control. And basically, merger control, so an acquisition will be reviewed only if there is acquisition of decisive influence. And then, if you're in between, possibly there is a gap in the law. So if there is just a company nominating someone on the board of from a competing company, it's not an acquisition, there's no acquisition of control, and it's not an agreement between two distinct firms. Even though, of course, the illegal information exchange can be, of course, prohibited by Article 101. And in the US, things are different. Of course, Section 1 of the Sherman Act prohibiting anti-competitive agreements, you need to have two or plus entities or firms, two separate firms. Basically, there is this sense that if you have only one firm and internal relationships agreements, this is not subject to Sherman Act scrutiny because this is about the internal business. And then merger control actually applies irrespective of decisive influence. So basically, Section 7 of the Clayton Act can apply also to partial acquisitions. So whenever there is an acquisition which would substantially reduce competition, Section 7 can apply. And also there is this very specific Clayton Act, Section 8, which just prohibits competing companies from sharing a director. And what is interesting now is that there is a renewed interest from enforcers to really enforce that. It's just a very brief chart of interlocking directorates in America. So I'm not covering the whole things with acquisitions because my expertise is very limited in that area of the world, sadly, but just to explain that in Chile and Colombia, they also prohibit interlocking directorates between competitors. And in Chile, there has been some enforcement activity last year. Argentina and Brazil, I think it's slightly more subtle. Basically, if there is someone sharing top roles within two firms with an intent to reduce competition, this can be an offense. But apparently there hasn't been much enforcement activity against those interlocking directorates link. But then this is for me maybe a question that I'm going to ask you and that you can clarify with me. So, do we need to change something, our understanding of how the rules are designed? So, is the undertaking paradigm that we really use in Europe outdated? Now we have complex corporate structures. We can no longer think about one business being separate from the other. You have really very, very complex structures with the investment being really disjoined from business operations, holdings, and all that stuff. we now understand that there is a distinction between legal control and economic control or influences. And these complexify everything, but we can no longer maybe just use set of definite principles. That being said, we are already seeing some changes and some awareness of the complexity of corporate structures and how they may produce effects. Merger control. In member states of the EU, they use wider concepts of influence. They no longer, they don't just, they can actually review a larger set and pools of acquisitions. So those who confer material influence, so for example, in the UK, so no longer a member state, or in Germany, basically there are some tools by which minority acquisitions, which do not really give control, but some influence, can be reviewed. And those financial or corporate links have been discussed actually by the Commission. So in the acquisitions Dow and Dupont and Bayer and Monsanto, there is discussion of the impact of common ownership links, so all these financial links. So definitely it is now part of the assessment. And since the judgment from the court in Taocast, Article 102, which is about prohibiting abuses of dominant position, Article 102 can be used to review any anti-competitive acquisitions ex post. So meaning that if we have an acquisition which does not confer control, which does not trigger merger control review, if we have an issue, we may still use Article 102 as a tool ex post to challenge an anti-competitive acquisition. So now the tools are broadening. And okay, and another point which is quite complex, but just to say that the EU is really already looking at internal workings within corporate groups. It is with the single economic entity, and basically there is a lot of cases about attributing liability for the breach of competition law by a subsidiary, so within corporate groups. And there's even the case where a subsidiary has been kind of held liable for the misconduct of its parents. So it looks like a reverse thing. But in any case, there's a lot of kind of, when we say corporate veil piercing in competition law for various reasons, and it's very much debated. So meaning that competition law is definitely looking at the internal boundaries within undertakings, corporate groups in its activity. So now more strictly on common ownership, so those financial links and interlocking direct rates, actually, do we care about this? So first question is that other scholars, other enforcers do also care, maybe. So indeed, I think we need to really speak together with corporate lawyers, governance, corporate finance people, and say, okay, are you also concerned? Do you find issues with having lots of individuals sharing, sitting at the board of different companies, competing companies? And then maybe corporate lawyers will say, yes, we have maybe conflicts of interest. If a director sits on the board of Apple and of Google, maybe we have conflict of interest, maybe there is a breach of loyalty duty. So that's very interesting to kind of speak to them and see what are their tools and remedies. But also I say that we need to look at those links in aggregate, because in isolation, if you have just one person sitting on the board of two competitors, it's maybe not too much of an issue. They may bring expertise. So we need also to look at the good efficiencies arising from that. So I think my point is that for those links, and for it to be an issue for competition law, we need to look at the aggregate aspects. We need to look at within one economy, one sector, what are the links, the extent of those links. And we have Azar, an economist, who actually already established the correlation between networks of financial ownership link and interlocking direct rates. So I say we need to understand networks of those links. And before this, there's a lot of work for us researchers. We need to map both networks. So that's what I've started doing with some co-authors. And also we may wonder if there is not an issue, you know, if we find that there are networks, maybe it's just a reflective of corporate elite, you know, dealing with lots of things, and in which among which there is lots of acquaintances, and they can maybe run corporations together. It's not because we would change the law that they would stop existing, these corporate elites. And also, do we have some issues of ethics, of whatever, with some investment models? You know, maybe the one with institutional investors, private equity may raise issues beyond the realm of competition policy. And finally, we need, of course, to look at competitive effects and the wider economic impacts beyond, indeed, just prices and so on. So this is just an illustration of the network, the fact that we may have in isolation some links, but it's important to look at those on aggregate. And that's the end for me. So thank you for your attention. And if you're interested in more of these, I have a book published a few years ago on these issues. So thank you for your attention, and I look forward to your questions.
Thank you very much, Florence. It was an excellent presentation with a big overview of the relation between competition law and corporate governance, and your books is very good. So I also endorse your invitation to buy and read your book. And now let's pass the word to Danielle.
Thank you, and thank you so much, Florence. I really enjoyed that presentation. Thank you for including me in this panel. So what I will do first, I will share my screen. And I think it would be fair to say that this project that I will be presenting, I think, demonstrates this intersection that Florence talked about throughout her presentation between corporate governance, capital markets, and competition law. So what I do in this project is to take, I think, a refreshing, I'll say, antitrust perspective on a growing phenomenon in the US capital markets, which is the rise of institutional investor coalitions. The main argument that I make in this project is that these coalitions, which usually revolve around corporate governance issues, are capable of creating competitive distortions in capital markets, which are markets in which institutional investors, which are the members of those coalitions, compete with each other. And to illustrate this contention, I focused on one particular coalition, a very powerful one that strongly emerged over the recent, I'll say, 8 years, which is the coalition against dual class structure. And what I show in this paper is that the collective efforts of the coalition to inhibit the use of dual class structures in IPOs, in initial public offerings, this coalition creates a cartel of buyers in the primary market, which is, as I said, one of the capital markets in which institutional investors compete with each other. Now, as a general background, because I'm not sure everyone here knows, but a dual class structure consists of 2 or more classes of common stock, which are differentiated in their voting rights. This share structure, which deviates from the traditional one share, one vote structure, allows the holders of the shares with the superior voting rights, which are usually the founders or other corporate insiders, to effectively control the company even after the company goes public, without having to own the majority of its stock. Now, although dual class structures have been around the US since the 19th century, only a relatively small fraction of US corporations chose to adopt this structure, mainly from the media sector. However, over the past, let's say, 20 years, but most of it is the last decade, an increasing number of companies, particularly in the technology sector, has created a share structure with 2 or more classes of common stock. This list of companies include a lot prominent known companies such as Google, Facebook, Snapchat, LinkedIn, Airbnb, Zoom, and many other companies that you are probably familiar with. Now, the increasing number of companies that went public with this dual class structure has sparked an academic debate on the merits and the drawbacks of the dual class structure with two very different views. So on the one hand, we have a group which I call the red light group, which consists of scholars who object the dual class structure and associated with governance risks and management entrenchment. These scholars largely focus on the private benefits of control, and they call to ban or to the very least limit the use of dual class in IPOs. Now, the green light group, on the other hand, consists of scholars who acknowledge the potential benefits of this share structure. For example, some of the scholars argue that this structure isolates managers from Wall Street's short-term mindset and allows corporate managers to pursue their vision and manage the company without without the concern of being fired. And in addition, some of the supporters of this structure also argue that the structure reduces the relative voting power of public shareholders who are often insufficiently informed in a way that can actually maximize fair value. Now, I'm also tempted to include in the green light group the SEC, the large stock exchanges in the US, NASDAQ and NYSE, and several state bar associations, given that these bodies, and I will talk about it a bit more, refuse to respond to calls from the institutional investors, those members of the coalition against dual class to restrict the listing or the registration of dual class companies, while recognizing that this structure is important in terms of encouraging innovators to incorporate and to access public markets. Now, in terms of the empirical evidence, there are a lot of studies in dual class shares, and these studies are very inconclusive. There are studies that support both views. On the one hand, we have some studies finding lower stock returns for dual class companies compared to single class companies, as well as higher level of management entrenchment. Other studies, on the other hand, show that dual class structure often have better financial performance and that certain types of dual class company display higher long-term shareholder returns. I'll mention one particular recent study that shows that over the 10-year period from 2007 to 2017, unequal voting stock outperformed the market. Now, despite the inconclusivity of the empirical evidence and the different views of legal scholars and economics, a large group of institutional investors, some of them are the largest in the world, including mutual funds and pension funds. And as Florence mentioned, the big three, BlackRock, State Street, and Vanguard, I'll also mention that these big three are also part of the coalition. They have recently took both collective and individual actions against dual class issuers, arguing essentially that this structure has no place in the public market and that it should be banned. Now, I'll say that in the US, and I think that from an antitrust perspective, the organizations that I'm going to talk about are very important. And since this is an antitrust conference, I'll say a bit more about it. Most of the collective actions have been undertaken by institutional investors consortia, which are trade associations that focus on coordinating. They do a lot of things, but one of the things that these associations are doing is coordinating corporate governance initiatives that reflect the views of their institutional members. So two prominent consortia that have been highly involved in the coalition against dual class is the CIA, not the CIA that you're familiar with, but CIA, which stands for Council of Institutional Investors, and another organization, a newer one called ISG, the Investors Stewardship Group. So these associations represent the institutional investors, mutual funds, pension funds, and other union funds, and they represent a lot of the largest institutional investors in the world. And just to put some numbers on it, each of those institutions that I mentioned, the CIA and the ISG, represent institutional investors with combined assets of over $30 trillion. So we're talking about most of the largest institutional investors in the world. This organization these associations are very, very powerful. And what these organizations have done, mostly the CIA, by the way, just to give you some examples of the coalition's effort, is, for example, approaching the SEC and the US stock exchanges on behalf and with endorsements from its institutional investors, members, and asking those bodies, the SEC and the stock exchanges, to ban the listing of companies that wish to list with dual class structure. Now, when the SEC and the exchanges refused to do so, as I mentioned earlier, because they recognized the potential importance of this structure, the CIA approached index providers, which are private companies whose largest clients are the institutional investors themselves, and called them to exclude dual-class stock from prominent market indices. And in this front, the institutional investors community have had much success, and two of the largest index providers, the S&P Dow Jones and the FTSE Russell, decided to exclude dual class from many of their indices. I'll say that the S&P Dow Jones did decide very recently to change its decision after a couple of years, but this initiative was successful without a doubt. Another initiative that is worth mentioning is a publication of a list by the CIA on its website, a list that the CIA terms dual class enablers. And this list essentially includes the names of all board members of dual class companies that listed with that did an IPO with the share structure. And the goal of the publication of this list, and here I quote the CIA, is to sanction these dual class enablers by voting against them and withholding support from them at other single class boards on which they sit. I will also mention the open letters sent by individual investors as well as by those associations on behalf of the institutional investors to many IPO companies that plan to launch an offering with a dual class structure. And in fact, most of the companies that went public with a dual class structure since Snapchat in 2017 have received these public letters, which urge them to abandon this structure, or to the very least include a sunset provision, which is a charter provision that provides for triggers that result in all companies' shares being converted at some point into a single voting share class. And, I'll just give you an example of a letter. You can see here, this is one of those open letters, and you can see how strong those statements against dual class structures and against dual class enablers are, those directors that I mentioned are very, very strong. And this letter, by the way, was sent to Airbnb. Now, and I'll say that recently, even this efforts received a more official title. In August 2022, institutional investors formed the ICEV, the Investor Coalition for Equal Votes. And clearly the main goal of those initiatives and the coalition in general is to deter companies from going public with this share structure and send a very strong signal to the issuers and the markets that this share structure is not a best practice and is therefore flawed. And as I mentioned, despite the fact that we don't have a very conclusive determination regarding this share structure. Now, from a corporate law perspective, the coalition against dual class, like other investor coalition, does not raise any particular concerns, but it may be even the case that it's the contrary. For many years, investor coalitions have been viewed as a solution to a problem rather than a problem in and of itself. And the underlying notion is that cooperation between shareholders can help mitigate the rational apathy that characterizes public shareholders and help solve the collective action problem. And also, since investor coalition usually comprised of institutional investors that are viewed as sophisticated market players, most chances are that these coalitions, at least in theory, will effectively monitor management and promote adequate governance standards potentially reducing managerial agency costs and improving firm value. Now, in that context, it is important to note that while some scholars, particularly those who belong to the green light group that I mentioned, have criticized the efforts of the coalition and more specifically the agenda that the coalition promotes, the very existence of the coalition did not raise any red flags. In fact, and somewhat ironically, I think, several scholars who belong to the red light group even suggested in the past that institutional investors should join forces against dual class issuers in order to effectively deter companies from going public with this share structure. What I do in this article is essentially to challenge this prevailing positive view on investor coalitions by analyzing this coalition from a different perspective, which is the antitrust perspective. And I explained that corporate law perspective overlooks the fact that institutional investors are not merely co-owners of companies, but are also competitors in capital markets, as I mentioned at the beginning. Most notably in the primary market, the market on which this article focuses, institutional investors are not even co-owners yet. They are potential buyers of shares who compete with each other on share allocation in initial public offerings. In other markets, such as the secondary market, these investors also compete on relative performance based on which they are evaluated and compensated. Now, the main concern that I raise in this paper is that these institutional investors will take advantage of the freedom they currently have to establish shareholder coalitions as means to form cartels in disguise, which can result in anti-competitive distortions in capital market. And I explained that this anti-competitive risks exist even in cases in which the coalition deals with issues that are perceived as benign from an antitrust perspective, such as different corporate governance arrangement. As I show, a coordinated push for certain corporate governance arrangements, such as the single class standard, can affect prices and other terms of securities sold in capital markets. Now, the different approach, and here I also, it also relates to this borderline that Florence mentioned, but the different approach that is mandated from an antitrust perspective compared to the traditional approach to shareholder coalitions under corporate law reflects a certain tension between the goal of corporate law to encourage cooperation between shareholders and the goal of antitrust laws to restrict collaboration among competitors. Now, the test that I suggest applying in order to determine under which lens an investor coalition should be analyzed is the borderline test. The idea is that we should first determine whether the impact of a coalition is confined to the boundaries of the firm, only affecting the targeted company that the coalition members jointly own. And in such case, a corporate law analysis is the adequate one. Or whether the coalition also affects the markets in which the coalition members compete with each other in a way that may provide them with an unfair advantage over other market players. In the latter case, the appropriate contextual framework, to my opinion, is antitrust law. And the coalition against dual class is a classic example of a coalition that operates in the boundaries between firms and markets. Since the coalition targets mostly companies in the IPO market, a juncture in which, as I said, the coalition members are not even co-owners of companies. And because, as I will show, the coalition has the capacity to affect prices and other terms of shares sold in the IPO, this coalition should be analyzed through an antitrust lens. And this is exactly what I do in the paper. And this is also what I'll do in the several minutes that I have for my presentation. So according to the antitrust analysis that I do, what I basically show is first that the different initiatives that I mentioned earlier meet the definition of a concerted action under US competition law. And later I show how these efforts distort competition in the primary market. What I do here is mainly focus on the market power of the coalition, the members of the coalition. And I explain that because the coalition encompasses a large number of institutional investors who are dominant buyers in the IPO market, a market that has become much more concentrated over the last few years, mostly because a lot of large institutional, giant institutional emerged. And also because this members of the coalition are very influential in terms of affecting the governance of companies, the power of the coalition is immense. And in that context, I should note that in the US, institutional investors account for most of the expected market demand for public offerings. And on average, they receive around 90% of the allocated shares. And on top of that, institutional investors are considered as providers of very valuable pricing feedback during the book building process, a process that ultimately determines the price of the offering. So these institutional investors are not only large and buy a lot of shares in IPOs, but they also function as providers of valuable pricing feedback, and their feedback on many things, including the share structure of the issuer, has the capacity to affect the prices of the offering. Now, I also explain in the paper that the collective negative response of institutional investors to the dual class structure allows the members of the coalition to cooperate as buyers and leverage their negotiation power over issuers. And this in turn can depress the price of dual class shares, or to the very least, enhance the control rights attached to the shares. For example, by pushing issuers to include a sunset provision, as I said, a charter provision that provides for different events that or time limit that at the end of which the all shares will be converted to one type of stock. There's two potential effects: the ability to affect the price of a stock and the ability to affect the governance, the control rights, the governance terms are capable of creating the same economic harm that competition law was designed to prevent. So we have the price effect, we have what I term the governance terms effect. Now, I'll just talk very briefly about each one of these effects to show you how it is materializes. So as to the price effect, my claim is that the coalition creates a mutual understanding among its members that this share structure is flawed in the sense that it deviates from what is a best practice, and therefore a company that has to go public with a dual class structure should bear a price tag. Now, several institutional investors even stated publicly and explicitly that a dual class stock should be discounted. And here I quote BlackRock and the director at one of the largest pension funds in the US, the California Public Employees Retirement System, who essentially say exactly that there is a price tag. And again, please remember that no empirical evidence is conclusive on that. And actually the recent studies show the opposite. Now, and you know what, I'll give you some, I presented this paper a couple of months ago, and there is a recent paper showing that a lot of institutional investors really like to enjoy, if you look at the relative ownership of institutional investors, they like to buy stock of dual class companies despite everything that they're saying, not just in IPOs, including IPOs, but not just. It seems that there is like what they say and what they do in terms of their investment strategy is not very aligned, because they are very much invested in dual class companies. Anyway, going back to the price effect. So my claim is that this negative view automatically sends negative price signals to the markets and impacts the underwriter's perception as to the price at which the offering is likely to succeed. And as several legal scholars and practitioners explained, it is very hard to believe that such statements are not conveyed to the issuer and underwriters during the roadshow and during the book building process, which, as I said, determines at the end the final offer price. So by doing that, the coalition artificially inflates the penalty imposed on dual class issuers, potentially leading to underpricing of such stock in IPOs. And in the context of the price effect, it's also worth mentioning that the index exclusion sanction that I mentioned earlier, excluding dual class companies from prominent indices, is in and of itself is capable of influencing the share price, because index inclusion increases the demand and the liquidity of the stock that are included in the index. Stocks that are not included, they have lower demand and liquidity, and so this has this initiative that led to the sanction of index exclusion by itself had a price effect. Now, a possible support for this price distortion of dual-class stock in the IPO market can be found in recent empirical research, which showed that the first day bump, the price increase of a stock in its first day of trading, which is considered a very good indicator for IPO underpricing, is almost twice as large for dual-class stock compared to single-class stock. And also another anecdotal evidence, which I find interesting, is that this is a list of the highest amounts of money left on the table in IPOs between the years 1985 and 2022. And as you can see in this table, 9 out of the 10 issuers that left the highest sums are dual-class issuers, 6 of which had their IPOs between 2020 and 2022, when the coalition against dual-class was particularly active and done a lot of its initiatives against dual-class IPOs. So what we can see is that despite the fact the decision of these dual-class companies to go public with a dual-class structure received much criticisms from the institutional investor community, the first day bump, this price increase in the first day of trading were particularly high. And as a matter of fact, these companies left, as you can see, billions, hundreds of billions of dollars on the table, as they could have received twice as money for the shares that they sold. Now, maybe I should have done that earlier, but this is those companies like Airbnb and Snap and Bumble, Snowflake, a lot of those, Rivian, the automotive company. Very briefly on the potential effect of the coalition on the governance terms attached on the stock. So what I explain in the paper is that this effect, I explain how it materializes and what are its effects. And what I explain in particular is that I look at the antitrust literature, and there is a very interesting strand of research on standard setting association. So I developed the argument that the efforts of the coalition to set the equal voting rights standards may be analogous to the standard setting process, both because the coalition can affect the prices of dual class stock, and also because it can ultimately lead to exclusion of dual class companies from the market or from different indices. Now, I will mention that a standard setting process may be viewed as a collusive practice regardless of the reasonableness of the promoted standards. There is a very famous case called the Fashion Originators Guild of America, in which the Supreme Court denounced the well-intentioned activities of a trade association to eradicate the counterfeit clothing market, viewing it as an attempt to become an extra governmental agency. So there was no argument that what they're doing is, in terms of from a policy perspective, is good, but the idea was that not market players should do it, but the government should act with regard to this. So using the same rationale, the attempt of the coalition to set an equal voting rights standard should sound an alarm bells even to those who view the equal voting rights standard as worth adopting, meaning that even if you belong to the red light group and you think that this is wrong, it doesn't matter. It doesn't change the fact that from an antitrust perspective, we do have a big problem, and that this issue, in order to the issue of dual class structures, even if this is something that we view as undesirable, this should be determined by different government agencies and not by the most powerful market players in initial public offerings. Now, and it's probably obvious to most students, but I'll just mention that that in the antitrust literature, the possibility that competing buyers will use their collective power to promote non-price terms in a way that is anti-competitive is acknowledged. And as I mentioned earlier, it is very often associated with the standard setting process. A process that raises a lot of red flags because it involves cooperation among competitors, just like in the case of the coalition. So in the very little time that I have, I'll just say that in the paper, if you want to read more, I'll also talk about how the two main market effects, the price effect and the governance terms effect, are capable of reducing social welfare, while I focus on the distributional and locational inefficiencies associated with this market effect. And very briefly on the policy proposal, what I essentially suggest is to apply antitrust scrutiny on investor coalitions, and particularly those coalitions that emerge at the borderline between firms and markets. And I propose to limit the ability of institutional investors to coordinate their position, and perhaps even to restrict the freedom they currently have to communicate with each other in their capacity as competitors. I also talk not enough. This will be in an offspring paper, but about those organizations that I mentioned, those trade associations, which are currently on the rise, and I explain that I argue that they should be regulated as standard-setting organizations for antitrust perspective purposes. So that's it, I think. Thank you so much, and I look forward to your questions.
Thank you very much. It was a very nice presentation, and I think it's very interesting because usually I read these on articles like good governance is like something that nobody is against, because good corporate governance is good for everyone, and there is no negative effect. And this idea that you have a process of organizational standardization, it's very different from what's usual in the literature. And also another thing, usually the idea of active minority investors usually is seen as a good thing in the literature of corporate law. Usually people complain about, oh, you have these investment banks, these private equity funds, and they are too passive, and they don't engage in decisions, and they don't do the work of supervising the controller of the company, and they don't do the work of representing minority interests and protecting minority shareholders from appropriation of rents or of money by the controller investor. And both of you show that the idea that this minority investors stay a little more active could pose challenges to antitrust or to competition law. Because if they want to know more about the company, they will get more information. And then if they have interlock directorates, they're going to have information for a lot of companies, and they can exchange that in meetings for decisions on each company they participate. And also, if they start to become more active, they maybe can influence more prices. That's like the main variable of competition law. And if they can influence prices without having the legal control of the company, then maybe you can have a point where competition law doesn't get, and it stays the shadow. So do you think like this interlocking directorates, or this idea that companies have a same pattern of deciding things, by standard of organization, the organizational process of decision, can be considered like a plus factor for cartels, or can be considered as something bad and should be more regulated by competition law? I don't know who wants to go first. Maybe Florence.
Okay, thank you. And Danielle, I was really fascinated by this presentation. It is really so much at the heart of interaction between corporate finance, capital markets, and antitrust. And you do a great job in looking at antitrust law. And it's a great idea to have this standard setting organization framework, because I think I was trying to think about what tools could be used, collective boycott, kind of prohibition, but it's something slightly different because they really try to influence. So, and also like the fact that you really try to get a full spectrum of the literature, empirical study, and it's, I think, a very powerful study then. So to answer your question, Vinícius, yes, I agree that it seems like a dilemma and a contradiction between corporate governance, which says, okay, we need to have investors engaged in controlling, and we need to fight against those really passive who do nothing and who let managers, run away with the money or whatever, do bad things. And then now we come with competition law saying, actually, we have an issue with institutional investors who are a bit more too active. They try to really achieve, best value for their clients, but maybe they're a bit too active in their industry, in the industry in which their targets are active. And I think there's a bit, maybe probably a love between both fields, because saying, okay, competition law may be really just obsessed with impact on prices, and the evidence is not so strong that we should maybe kind of try to discard everything that has been done in the corporate side, and saying that we should have investors more active. So yeah, so I think there may be some proposals that to try to limit in a way the powers of investors, those within industries. But in a way, I think maybe the solutions may be more, okay, maybe there should be limitations about having so much of the diversification within an industry. Maybe it's understandable that they want to diversify, but why don't you just do really across industries? So maybe there could be some specific sectors who are highly concentrated, for which there should be more scrutiny. But then it's interesting because the key question about common ownership by institutional investors is really the channels of influence, because there are these empirical work by Azar, Schmalz, and Thepot, who says that there is a potential, a correlation between concentrated common ownership and prices. But then the big question is, yes, but in practice, how does that happen? And I think where we really need to work with the corporate lawyers and corporate finance is that also now we understand that maybe you have some common owners who want to achieve price increase, but then you may have the rest of the owners who may not share that. So, and that's really where we have to understand these mechanisms of different type of investors and their importance in the final decision makings. So yes, that's my view on that. I think there is an inherent conflict, but at the same time, Danielle's work seemed to suggest that the corporate governance and competition concerns really go hand in hand in her case. So that's quite satisfying to see that maybe corporate governance issues go together with antitrust issues, even though maybe some of the red light people would not agree or whatever. So that's my thoughts.
Thank you, Florence. And Danielle showed that the price can be higher if you go to capital markets that have like this institutional. And this is an important price in the economy because access to capital, it's essential. It's critical to have entrepreneurship and have more companies in all the sectors and have then more competition pressure. And if you maybe if you forbid, for instance, common ownership or interlocking, maybe you have less investors and the access to capital markets is going to be harder, even harder. But I see the same situation in Brazil. Like when I participate in operations in the capital markets, it's always the same people, always the same intermediates, like always the same institutional in financial institutions, always the same law people, always they control the market. I see that also in Brazil. What do you think about?
Vinícius, can I also respond to your question?
Yes. Yes, sure.
So I'll say that I think, you know, a lot of people often say they don't think that antitrust law and corporate law have much to say to each other. It's like two different, and I think this was traditional the view, and I think over the last a couple of years, and I think this is mainly due to very dramatic shifts in the capital market landscape. Also in Brazil, I'm sure, but it happens in Israel, in Europe, in the US, when you see a growth of institutional investors and much more concentrated markets and investors that are much more influential than they were in the past. I think that this intersection that Florence researchers started researching a few years ago, I think it becomes it's super relevant and super interesting. The main problem that I recognize is that this intersection can be can appear in different markets. So on the one hand, we have the product markets, the Azar research that Florence mentioned, and other that talk about how common ownership affects product markets. There is also relatively new studies and articles about labor markets and how they are affected by the rise of institutional investors. Azar has one paper on that. There is also a very interesting paper by Goshen and Levy that deals with it. So we have those markets, but we also have the capital markets. And I think capital markets, like the project that I presented, is different in the sense that, as opposed to labor markets and product markets, which are the markets in which institutional investors, the portfolio companies compete with each other, the capital markets are the markets in which the investors themselves compete with each other. And I think that a very interesting policy question that must be addressed, at least in the US, and I'm sorry that I'm not familiar enough with Brazilian law and also with the law in Europe, but there is a problem because usually antitrust law, there are some challenges in terms of detecting anti-competitive behavior when we talk about product markets and labor markets, because the effect is like, there is a very, it's not a direct effect. We have an effect through ownership links, through directors. So it's very hard to prove. And so antitrust law, which is no question, this is the right conceptual framework within which to explore it, has a lot of challenges in terms of enforcement and detection. On the other hand, when we talk about capital markets, it's not, although it's much more easier to see the competitive effects because we're talking about competitors that compete with each other. Like the problem there is that, at least in the US, there is a doctrine called the implied immunity doctrine, which essentially says if it's a matter relating to capital markets, then the SEC is the regulatory agency that needs to deal with it, and it's immune to, and any type of potentially anti-competitive behavior is immune to antitrust enforcement. And it's a little ironic because this is where it's easier to detect those anti-competitive behavior. So it's easier but then antitrust law cannot apply. It's easy. It's harder to. I would be very interested to hear from both of you now or later. But how is it like in other regimes in terms of the ability to enforce antitrust law on anti-competitive behavior in capital markets? I was wondering if it also if you also encounter this problem, this sort of paradox.
Yeah, thank you, Danielle. I think it's indeed very interesting to see that the issue is in a different type of market that's in competition law we are used to deal with product markets, a specific industry. But all these trends invite us to really think about an enriched version, and that there is indeed this competition in itself in given sector. So yes, I think this is part of the process also when we have growing concerns about private equity. In a way, it looks like we want to bring antitrust in a field where we used not to look at, because we thought, okay, it's financial stuff and we're apart from it. But now there's a field, maybe we could use the competition then to fix some issues. So the question is whether it's the right tool or not. But I think in your case, yes, I think, well, in the EU, definitely, there is no, I don't think there would be immunity in itself from any sectors. That being said, traditionally, indeed, investment stuff are kind of within other regulators, within other fields, and even though there is, I think, where there's more liability within corporate groups, and when you have an investment company who kind of owns maybe almost all of a subsidiary, then it can be liable for competition law. So in a way, but it's still again through the conduct of the subsidiary on the product market. I think there's still a sense that what matters is maybe the product market behavior. Nonetheless, there's no immunity of an investor in that sense. And maybe some argue that it goes too far to have maybe an investment fund fully liable for the breach of their subsidiary, but others say yes, but if it's like full legal ownership, maybe you need to make it sure that they do the right thing and they try to prevent subsidiaries. Yes, but I think it gives lots of food for thought, and even more to think about. Yes, but how about there? I think it's the same when we speak about the competition in the market for corporate control. Usually in competition, I don't think we really look at it and okay, we say maybe, oh, it's good to have also competition at the level of corporate control, and we let this go unless it's reviewed within the merger regulations and so on. But usually we are kind of still focused on the product market, and you're right, with the labor market developments, but actually there could be employers dividing their markets, and that's great that we have this awareness, but now we need also this awareness going a bit upfront as well, where I think in your case, it's great to hear that it's where we could really have a case, and an easy one if we would consider that. But
I think the main takeaway is really, I think, given those changes that we've talked about in capital markets and how they affect product markets and labor markets as well, I think the main takeaway, and Florence talked a lot about it, much more than I did, but it's really the regulatory gap. I think this is an issue that must be addressed in a lot of, not just the US, but clearly this is a more global problem that appears in a lot of companies and many regimes, a lot of countries and many regimes.
Yes, no, very good. Like I agree that there is a regulatory gap. Brazil, I think, is the same as Florence said. Like there is no formal immunity, but it's going to be strange to see the competition authority focusing too much on this market, because there is like the expertise is on the capital markets regulator, and usually they don't focus too much on competition pressures and like these things about competition for corporate control. Like we use a lot of models, but in Brazil, I think the same as in a lot of countries, there is no big pressure for corporate control acquisition. So these models that we use, they are not very connected to Brazilian reality, because the capital market is not so big, it's a little small. And we have the last case you had about creating the stock exchange. I'll have just one stock exchange. The acquisition of that led to just one stock exchange was approved by the competition authority, and one of the things that was that this stock exchange needs capital to help in the task of educating people to invest more in capital markets, and like it's good to have one good stock exchange with capital to invest and to then have more. So there is like a different assessment of this market also, and this idea that first you have to have a more liquidity in the market, a bigger capital market, then you're going to start thinking about competition in these markets, at least I see in Brazil. We're approaching the end, so do you want to do a final talk, Danielle or Florence, before we end?
No, I think it's all interesting to think about. Maybe we identify an issue, or in my case, but there's never any intention of having too strict prohibition, because we need to look at the wider impact. And with interlocking direct rates, I agree that in a way it's at the heart of freedom to do business to appoint board members. That being said, in a study that we did with some co-authors, we tried to establish a link between regulations on gender diversification, so gender quota requirements on board, and this may have an impact actually on networks. So maybe now you have to find a greater pool of people to have on boards of directors, and meaning that maybe this also explain a reduction in the density of the networks. But also indeed to come back to just to give an example of competition law case in kind of financial sector. It's we have the LIBOR case. It's these interest rates, and several banks were found to in breach in competition law at the EU level. So definitely there's no immunity, but then on the more complex things that I understand less and that everyone understands less, I think indeed there is less visibility of all these things. And I had never heard about those coalition of investors, and I think I want to read more about it, and I will read more on your work as well, Danielle.
Yeah. I was about to say a book a couple of days ago. So I look forward to see what we have a war here. So I still didn't get a response from our library, but I really look forward to reading your book. I'll say that mostly I think what I took and what I think it's because I focus a lot about the US and Israel, and it's really nice to see how things also appear in Latin America and in the EU. And I learned a lot from Florence's presentation. I really look forward to connect further in the future and see how our scholarly views can intersect as well. So thank you so much. I really enjoyed this panel. Thank you.